Yes, sir.
That's on jurisdiction.
And you're right.
makes reference in 2.8. It's the answering affidavit at paragraph 2.5. Now bear in mind this is the minister talking. He says, whilst the decision to proclaim the analogue switch-off date was taken by the Cabinet of the Republic of South Africa, it was briefed by the Minister on the process that was followed up to the date on which the determination of the analogue switch-off date was made. For this reason, the President will also be opposing the application and will inform the Court of the basis on which government opposes the relief on which the applicants seek in this application. So, what does your Lordship make of the fact?
So, that's at paragraph...
It's 2.5 of the answer, my Lord. Yes, it's at 010-9. What is your Lordship to make of this at interim stage? Well, your Lordship respectfully knows now unequivocally that it was the Cabinet who took the decision, that the basis upon which it was taken was going to be explained by the President. It hasn't been explained by the President, and the consequence of that respectfully is clear. We give your Lordship the reference in 2.8 to Minister of Justice versus SA Restructuring and Insolvency Practitioners, in which the Constitutional Court made clear that the absence of reasons for a decision is tantamount to arbitrary decision-making. So you have not been furnished with the reasons as promised by the President, and at this point your Lordship is therefore bound to accept that that absence of reasons means that the decision was arbitrary and hence fundamentally unconstitutional. My Lord, let me then turn to my third topic, which is the absence of consultation on the ASO date of 31 March. Now, that there was, my Lord, this is in paragraph 3 of my note, that there was an obligation on the Minister to consult stakeholders on the actual date of the ASO, once again permits of no doubt by reason of the ETV judgment. My Lord, consultation in general about an analogue switch-off date at some hypothetical time in the future is not good enough. It has to be consultation about the actual date of the ASO. My Lord, that was the error that the then Minister made in the previous litigation, and it is the error which the current Minister once again makes in the present litigation. My Lord, let me be clear on where this argument fits into the scheme of our submissions. I postulate
Yes. Yes, Lord.
Thank you, my Lord. My Lord, I'm now going to address the proposition that the actual setting of the ASO at 31 March is irrational, and really principally because it simply cannot achieve its intended purposes. To contextualize the argument, my Lord, your Lordship will recall that the facts demonstrate that there was a cabinet meeting on the 4th of December, and on the 5th of December it was simply announced that the ASO was now going to be 31 March. And your Lordship will also appreciate that by virtue of those facts, there was no prior notice of 31 March, nor was there any consultation on that date. So, what I'm about to address, my Lord, is why the result is irrational. Because of its failure to have regard to two of the critical questions which have to be factored into the determination of the ASO date. That is, the numbers of people who are going to be affected, and relatedly, the numbers of those persons who have set-top boxes and the backlog in the installation of those set-top boxes. So, my Lord, I address this topic in paragraph 4 of my references, and I start with the legal foundation for the argument, and once again, that is definitively established in the ETV judgment. And the first foundational principle is that the objective sought to be achieved is, and I quote from the judgment, the transition to digital television without causing millions of persons to lose access to television on the analogue switch-off date. Now that is the stated purpose of digital migration. It is expressly articulated in the digital migration policy, and it is repeatedly set out in the ETV judgment. I've given your Lordship 3 references to paragraphs 63, 77 and 78. Let me take your Lordship to 77, where the court said, it cannot be said that the Minister's failure to adequately provide an opportunity for persons to be informed about the need to register before the deadline, and thus to obtain accurate information about households requiring STBs, is rationally connected to a successful migration process. Without obtaining and considering such information, the Minister was not in a position to determine an analogue switch-off date that would mitigate the harm caused by such switch-off, which the Minister accepted was amongst the central goals of a successful migration process. So, my Lord, that is the object to be achieved. The second proposition is that steps must be taken to notify persons eligible for the receipt of STBs, that there would be, and again I quote from the Constitutional Court, the imminent loss of access to television on a set date and not a theoretical date in the future. That's what the judgment says at paragraph 67. And thirdly, a statement to the public of a need to register but without a deadline by which to register is insufficient. So, my Lord, in order to qualify as a rational decision regarding the ASO, there are two critical issues which have to be considered and addressed. The first, how many people will be left behind on the switch-off date, having regard to the fact that, as the Constitutional Court put it in paragraph 63, the objective sought to be achieved being the transition to digital television without causing millions of people to lose access to television on the switch-off date? And secondly, is the process of registration for STBs as well as their installation sufficient to ensure that millions of people will not lose access to television on the switch-off date? So let me turn to those two questions. And starting with arguably the most fundamental question in this case, and that is how many people are going to be left in the dark if the ASO is to proceed on the 31st of March, and to consider that question in light of the state's repeated promise, reiterated ironically in these proceedings, that nobody will be left behind. Now, my Lord, I'm going to approach this on two bases.
And can I also expand the foundation you just laid?
Yes.
With reference to what I presume will be pursued strenuously by the first respondent, namely the suggestion in their heads that the applicants are hopping on these millions of people without providing any evidence, as they put it, of that fact. I'm putting a question in agreeing with you that it's a fundamental question to consider, because there seems to be, if I understand the papers correctly, a play on the numbers to say the numbers are not what the applicants submit they are.
My Lord, I intend to address precisely that question immediately.
Yes.
And my Lord, I'm going to do it on two bases. I'm going to start with the Minister's own figures. I'm going to start with the actual figures which he accepts. And I'll demonstrate to you what those numbers are. And I will show your Lordship in due course in a moment why in truth the numbers are much larger. But on the most conservative basis, the numbers are still massive. So let me start with that, my Lord, if I may. And I stress to your Lordship that I'm going to be, in the first instance, adopting the most conservative approach. Conservative in the sense of the lowest numbers that can possibly be regarded as being effective. And I need to tell your Lordship immediately that there are certain inconsistencies in the Minister's evidence. Bear in mind, that's the approach I'm taking now. But the discrepancies are not of any significant magnitude, and I'll point those out to your Lordship as I go through. But Lord, I address these numbers in paragraph 4.3 of my heads. Let me start out with what the Minister says on affidavit, under oath. And as I stress, he's not particularly consistent. But in the first instance, this is the lowest number. He says, my Lord, and you'll find this in 4.3.1, that as of 21 February, says the Minister, 391,513 households were registered for STBs but had not yet received them. That's 391,513 on the Statistics South Africa ratio of 3.2 persons per household. That translates into 1,250,841 people, 1.25 million people. Now that is the lowest figure that your Lordship will find on these papers. It's not the accurate figure, but it's the lowest. There is then the Centec presentation to Parliament on the 27th of February. Bear in mind, Centec is really at the coalface when it comes to the question of installation. Centec gave the figure as of 27 February in Parliament as 421,000 households. That translates into 1.347 million persons. And then at another place in the affidavit, the minister says that, and I quote, this is in 4.3.3, there are currently 447,000 households which remain to be supplied with government-sponsored STBs, and that translates into 1,430,400 people. And our learned friends, in their heads of argument, accept that that is indeed the number, 447,000 households, and I've given your lordship the reference in 4.3.3. So, my lord, one is talking now at the most conservative basis of something between 1.25 and 1.5 million people who are yet to receive the promised STBs on the minister's own version. Those are the minister's figures. Now, it's important to appreciate, my lord, that it is not the minister's case that those admittedly registered households will have STBs actually installed by 31 March. That would require an installation miracle. And there is not the remotest suggestion that such a miracle can possibly occur. And the minister candidly accepts that there will not be any miraculous rate of installation. In fact, his stance is that even those who have registered will only receive their set-top boxes, or will only have them installed by the 31st of December this year. My lord, I give you 4 references to where the minister says as much in paragraph 4.4. So, my lord, it's actually not possible to know whether these 1.25 to 1.5 million people will receive their set-top boxes by year end. This is because in answer, the minister refers to a plan. But he's never disclosed that plan to the court or to the applicants. So this bald assertion, which I stress is exclusively within the knowledge of the minister, carries no evidential weight. Bald assertions, my lord, are as useless as bald denials. As the SCA has put it, my lord, this is not in my note. If your lordship could just take a note. The SCA said this in a case called A.M. Muller Group Limited versus The Gap. It's 2005, volume 6 of the South African Law Reports, page 568, Supreme Court of Appeal at paragraph 31. The court said affidavits in application proceedings must do more than make bald assertions. They must, in addition, provide the facts that support the allegations. So, your lordship is left in the dark as to what the plan is, and hence there is no factual justification for the imminent rights infringements which my learned friend Mr. Ferreira for MMA will deal with. But what we do know is that the minister told Parliament on 19 November last year, there he said that there were 469,370 households which remained without STBs despite having registered for them. And astoundingly, 90% of those households were registered over a year ago but had not yet received set-top boxes. That's in 4.6. So, my Lord, just to be clear, what will happen on the state's version if ASO takes place on 31 March? Approximately 1.25 to 1.5 million people will be subjected to a television blackout. Those who will be so subjected are the poorest of the poor, who are entirely reliant on the state to assist them with set-top box installations, and the vast majority will be subject to that blackout until at least the end of the year. Now, my Lord, a critical feature of this entire process was, of course, the promise made that no qualifying household would be left behind. And the obvious implication of this promise is that when switch-off occurs, qualifying households will not be left in the dark. In other words, on the date of the switch-off, they will continue to receive television broadcasts via set-top boxes, and that is indeed entirely consistent also with the Constitutional Court's finding on this issue. I give your lordships the references in 4.8, but in the first instance, the court held, and I quote, the STB registration process and the deadline for registration form part of the process leading up to the analogue switch-off. Said that at paragraph 46. And second, it held that the duty of consultation would need to address critical issues before the ASO, including, and I quote, the number of persons who qualify to receive STBs, who would like to register for STBs before the analogue switch-off date, and how long it would take at the current rate of installation for all households that wish to register to receive STBs to be supplied with such. Instead, my Lord, in a regrettable choice of language, the Minister repeatedly says that the process cannot be held to ransom. That's the word he uses by so-called latecomers. That approach, my Lord, we submit, simply turns a blind eye to the state's inactivity between August 2023 to October 2024. And we give your lordship the statistics in paragraph 4.10. Only 45,450 set-top boxes were installed between August 2023 to October 2024. Between August and December 2024, the department only managed to install 15,740 STBs. That's roughly 3,000 a month. And even though the state knew that in August 2024, well over 400,000 households required STBs, that is close to 1.3 million people, before December 2024, it installed only 61,000 STBs in 18 months. So, my Lord, let us be clear as to what is now taking place. On the Minister's own version, he is deliberately embarking on a process which he knows will not achieve the objective identified by the Constitutional Court to transition to digital television without causing millions of persons to lose access to television on the analogue switch-off date. That is the Constitutional Court's words in paragraph 63. And that, my Lord, on the most conservative basis, is per se irrational. And secondly, my learned friend Mr. Ferreira will address this, it is an unjustifiable limitation of rights. And of course, it is the state that bears the burden of justification. But my Lord, I said to your Lordship I was going to address this on two bases. First, on the most conservative possible basis, but secondly, on what the facts in truth demonstrate. In truth, my Lord, the situation is far more serious than the minister states. As we demonstrate, my Lord, at the current actual rate of installation, and on the somewhat radical assumption that there will be no further delays, 978,608 people, close to 1 million people, in registered households will be left without access to television at the end of the year. The Lord, I give you that in 4.30. But let me pause there, my Lord. The minister undertook to provide the court with an update on installation. I think I give your Lordship the reference in 4.13. Anyhow, it's in the answering affidavit at paragraph 13.8 at 010-82. That's in 4.13. I'm just checking if your Lordship has the reference. Answering. Anyhow, my Lord, that was a promise made by the minister. Now, my learned friend has informed me this morning that there is apparently an affidavit which is in the process of being commissioned, and I'm authorized by my learned friend to tell your Lordship that the figure of registered but as yet uninstalled STBs is 405,000 households. That, my Lord, is 1.3 million people. And my Lord, I've so far confined myself to the position of registered households. But if one considers the position of indigent but as yet unregistered households, the position is respectfully nothing short of catastrophic. We have presented to your Lordship the statistics compiled by the Broadcast Research Council of South Africa, which I stress, my Lord, despite the repeated denials in my learned friend's heads of argument, the very point to which your Lordship alluded, those statistics are not disputed by the minister. And I'm going to show your Lordship the references in a moment. That evidence reflects that approximately 28% of the population, that translates into close to 14 million people, 13.8 million people, rely exclusively on analogue television. And the minister's constant refrain is that there is no evidence that millions of people will be subjected to this television blackout come 31 May. Those claims, my Lord, are nothing short of startling, given the fact that the minister did not dispute those statistics. And indeed, my Lord, this is not even a case of an evidential omission. In relation to the statistics put up by the applicants, the specific response by the minister to the paragraphs in question is that the contents of these paragraphs, I quote, are not in dispute. That's at paragraph 4.15. So, my Lord, your Lordship was right, respectfully, to draw my attention to the countless denials in our learned friends' heads of argument. But, my Lord, those denials simply ignore the evidence. The statistics that are put up are admitted by the minister. So I accept, my Lord, that those statistics relate to indigent but unregistered households. But in answer to your Lordship's question, as to the actual number who will be affected, it is in the magnitude of multiple millions. But, my Lord, the Minister somewhat callously says that those people, the indigent but unregistered, are not his concern. He says that he only has obligations to those who have registered for STBs, but even in relation to those, he turns a blind eye to the fact that come 31 March, on his version, if one takes the apparently forthcoming affidavit, which puts the figure at 405,000 households, there will be 1.3 million people left in the dark. So, my Lord, it becomes important to appreciate what has in fact occurred in relation to registration for STBs since the ETV judgment. After the ETV judgment, a new STB cut-off registration date was set at 30 September 2022. I give your Lordship the references in 4.17. And throughout his affidavit, the Minister adamantly relies upon that cut-off date for registration, 30 September 2022, as being central to his obligations to indigent households to whom the state's promise relates, and he therefore discounts all those who registered after 30 September 2022. That is the Minister's stance. But, my Lord, I'm afraid it suffers from a fatal defect, one entirely overlooked, respectfully, by our learned friend in his heads of argument. It turns out that the Minister is grievously mistaken, because the evidence establishes that the government, in fact, decided to extend the date of registration beyond 30 September 2022. Yet, in a fatal about-face, the Minister now says that only those registered by 30 September are the beneficiaries of the state's promises. So let me tell you what the position is, first of all, at the level of fact. And I give your Lordship the reference at 4.20.1. On 19 November 2024, the Minister told Parliament that he and stakeholders had agreed to extend the registration deadline to September 2024. Now, my Lord, I've given your Lordship the reference. It's part of the slide presentation, which your Lordship will find at 002-169. You have the reference. Your Lordship doesn't have to go to it, because I'll tell you what it says. It says, agreement reached by BDM stakeholders during a workshop held on 14 and 15 August 2023 to extend registration timeline to 30 September 2024, and then it follows, allow 2 months, October and November 2024, and listen to this wording, my Lord, to wind up installations. So the evidence is unequivocal. Our learned friends and the Minister are simply mistaken in believing that the critical date is 30 September 2022. It was extended by agreement to 31 September 2024. And as the presentation to Parliament indicates, the intention is by November 2024 to wind up installations. Now, my Lord, that can only have one clear and respectfully logical meaning. If one has regard to the object sought to be achieved, by digital migration, and that is to ensure that people are not left behind. If one has regard to the promise made by the state, even on the most narrow and conservative basis, that those who have been registered will not be left behind, what your lordship is faced with, unmistakably, is a deliberate endeavour to embark upon a digital switch-off which will leave behind, at a minimum, 1.3 million people on the minister's own version. That is the simple, stark, and inescapable fact. My Lord, secondly, and we point this out in 4.20.2, public announcements and awareness campaigns from 2022 onwards informed the public that registrations remained open for set-top box installations, and by April 2024, the public awareness campaigns made no mention of the now rigidly adhered to but outdated deadline of 30 September 2022. The Minister, thirdly, has never previously, that is before filing his present affidavit, sought to justify the ASO date unilaterally announced by Cabinet as 31 March by reference to the cut-off date for registration as being 30 September 2022. That justification is never foreshadowed in any of the correspondence, nor in any of the Minister's presentations. And my Lord, respectfully, the reason is obvious. The registration cut-off date was extended to September 2024, as the Minister in fact told Parliament on the 19th of November. Fourthly, my Lord, there was no consultation with stakeholders on this fundamental shift. It gets back to your Lordship's judgment in the Telkom and ICASA matter. And likewise, as the Constitutional Court judgment in ETV makes clear, the purpose of that consultation had to be directed at determining the number of persons who qualify to receive STBs and who would like to register for them before the ASO. And obviously, my Lord, and as we point out in our heads, if there is a change in policy, which is permissible within limits, but where that does occur, it triggers the obligation of a hearing. And lastly, my Lord, and this is important, we are constrained to submit to your Lordship that the Minister has not been candid about this change with either the court or the public. And your Lordship will take a dim view of the Minister's approach, having regard to the fact that, as your Lordship I'm sure knows, the state has a higher duty in litigation to be candid with the court. Could I ask your Lordship to add one reference to 4.20.5 of my note? It's the case of the Public Protector versus the South African Reserve Bank, and it's reported in 2019, volume 6 of the South African Law Reports, page 253, Constitutional Court. And can I just draw your Lordship's attention to what the court said precisely on this kind of issue at paragraphs 155 to 156. The court said this: the public protector falls into the category of a public litigant. A higher duty is imposed on public litigants as the Constitution's principal agents to respect the law, to fulfill procedural requirements, and to tread respectfully when dealing with rights. The need to hold government to the pain and duty of proper court process is sourced in the Constitution itself. This is because the Constitution regulates all public power, and public officials are required to act in accordance with the law and the Constitution. And then in 156, in a concurring judgment in Batati Hill Municipality, Sachs J held that the constitutional injunction for our democratic government to be accountable, responsive, and open implies that candor is required from government officials when they are before the courts. This is also consistent with Section 165(4) of the Constitution, which requires organs of state to assist and protect the courts in order to ensure that they are effective. Now, my Lord, I am constrained to submit that the Minister has fallen short of those obligations in litigation as an organ of state. What is, perhaps to our learned friends' credit, is that despite this obfuscation, our learned friends accept, and I assume do so on the Minister's behalf, that, and I quote from our learned friends' heads, the reason why the government did not close the registration process is to ensure that no qualifying household is left behind. That's as our learned friends put it in their heads. Well, precisely, my Lord. And that is because, as it was put by the Constitutional Court, the STB registration process and the deadline for registration form part of the process leading up to the analogue switch-off. And this is in turn what the digital migration policy and the state promised. The only way that no qualifying household will be left behind is to install STBs before the ASO. That, it is common cause, cannot and will not happen by 31 March this year. My Lord, we therefore submit that there is a substantial case for interim relief, far stronger, we would respectfully submit, than the relatively lower standard of a prima facie case. And we submit that your Lordship should grant relief in the terms prayed for. We would respectfully submit it justifies the costs of 3 counsel. We don't suggest any more than that, and we would so move your Lordship. Lord, those are my submissions. Thank you, Lord. Lord, I said we would change places with my learned friend for MMA. If your Lordship will just give one moment for us to do that.
Thank you, my Lord.
Yes, Counsel.
My Lord, I will be acutely careful not to repeat any of the submissions which have already been made by Mr. Marcus. We propose with a slightly different emphasis, because the court will be aware that my clients are 2 non-governmental organizations who act in the public interest to protect the rights of the public. And we will be very careful not to repeat any of the submissions, but to focus our submissions on the impact of the proposed premature analogue switch-off date on those rights of the public. And with the court's leave, we will address that issue under the following 4 headings. Firstly, the question of the limitation of fundamental rights that will occur if analog switch-off occurs prematurely. Secondly, some brief supplementary submissions on the question of unconscionable state conduct, the promise that was made by the Minister. Thirdly, the issue of consultation, insofar as it relates to my clients in particular. And finally, the elements of an interim interdict, which we submit are plainly satisfied in this matter.
Sorry, you said the third.
The third was the question of consultation, insofar as it relates to my clients.
I see.
And the fourth is the satisfaction of the requirements for interim interdictory.
Yes.
My Lord, if I may move directly to the first point, the question of limitation of fundamental rights. Our learned friends for ETV have spent some time explaining to my Lord why on the facts there are indeed millions of affected people. We would only emphasize that even on the Minister's version, there are at least 1.3 million individuals who will be plunged into a television blackout as a result of the ASO date of 31 March 2025. That is because the Minister's, as Mr. Marcus said, lowball figure is some 391,513 households, which must be multiplied by 3.2 individuals, according to Statistics South Africa, which gives you roughly 1.3 million people. My Lord, that is the lowest possible figure of people who will be plunged into television blackout. Centec actually told Parliament that it will be about 100,000 more in their presentation to Parliament of a few days ago, as Mr. Marcus pointed out, and we would only emphasize in addition that there is a further cause for alarm from that Centec presentation, because what you see from it, it is at page 011-95, is that in this rush to get to a switch-off date, Centec is now only installing set-top boxes in 4 provinces. They have left out of account the other 5 provinces because they erroneously think that analog switch-off has already happened in those provinces. But they are wrong about that. It is only the SABC which has turned off its analog transmitters in those other 5 provinces. ETV continues to broadcast on analog in those provinces. But Centec and the Minister are trying to get to a date as soon as possible, so they're rushing. So they're focusing all of their resources on these 4 provinces, and they're leaving the other 5 out of account entirely. And we would simply wish to emphasize that that severely exacerbates the harm that will be caused, because it means that all of this progress which is being made and the updates which our learned friends are going to place before court is progress which is being made only in 4 provinces, but 5 provinces are being ignored entirely. And as Mr. Marcus has submitted, we have no idea how long these 1.3 million people will be left without television for, because the Minister either does not know or has not told this court how long that blackout will last for. So at least it's 1.3 million people are going to lose access to television for an indeterminate period of time. That is the first fact which is common cause.
Well,
this
whatever. There's one thing that I struggle to understand. If Centec is the implementing agent on behalf of government or the Minister, and they commit an error regarding installations by suggesting that there's been a switch off already in the other. Now, I don't understand how that misunderstanding can happen, or that error can be committed, because Centec, more than anybody, if my understanding is correct, is the one agency that should know exactly the facts, the correct facts, where switch off has occurred and where it has not, because it is the implementing agent.
Yes. I think the confusion has arisen, my lord, because both the Minister and Centec, it is correct that the SABC has switched off its analogue transmitters in those provinces. And I think the confusion arose because they thought that there had been a universal switch off. But as I understand from the papers, that is an error of fact, because in fact ETV continues to broadcast on analogue in those provinces. I can't account for the error other than to say that it appears to have arisen from the fact that the SABC has in fact turned off in those provinces.
But even if SABC has turned off, wouldn't Centec be the agent, or is it not involved?
No, Manu, I actually don't know the answer to what Centec's involvement is in actually turning off the transmitters.
Yes.
I would have to have a look.
Yes. Well, my misunderstanding, if it is, arises because SABC is a public broadcaster.
Yes.
Where I would imagine the Minister and Centec would have the correct facts and so on.
Yes.
But if you have no instructions in that regard, it's fine.
No, my lord, and I'll just ask my junior to get the references to the pleadings where ETV makes the allegation, and as I understand, it's not disputed that it continues to broadcast in those provinces.
Yes, thank you.
But my lord, our submission was simply that it exacerbates the harm, and it means that the period of blackout is going to be longer because those individuals in those provinces are not currently getting installations at all.
Yes.
The other form of limitation which I wanted to draw the court's attention to, which has not been addressed at all by the Minister, is the massive harm which will be inflicted on broadcasters. When I say broadcasters, I mean in addition to ETV, which has made its own case, the SABC and the 6 community broadcasters, which are all reliant upon analogue broadcast. My client is concerned about a rich and vibrant ecosystem of expression in which a range of different views and a variety of sources of different information can be received by the public. And what my client says, which is undisputed in the answering affidavit, it's from pages 003-13 to 003-21, and it's paragraphs 34 to 54, is that if you switch off analog transmission before a sufficient number of audience members have managed to migrate to be able to receive digital transmission, you will devastate the operations of these broadcasters. And the mechanism is quite simple, because if you switch off analog broadcasters while those audience members are not able to receive digital, that means that your advertising revenue is going to fall through the floor. And so what my client says at paragraph 54 of the answering affidavit is he says, if analog free-to-air services were to be switched off, free-to-air television's audiences on any platform would drop from a total of 54% of the population, taking into account current analog DTT and DTH, to only 26% of the population, leaving 28% entirely without access to television services of any kind. So the effects are twofold in relation to the value of expression. Number one, we all agree 1.3 million people are going to suddenly lose access to television completely. And number two, the SABC and the 6 community broadcasters are going to be commercially devastated because their audience is going to be cut in half overnight. That is undisputed at the level of fact. My lord, the reference to the pleadings where ETV makes clear that it continues to broadcast in analog in these 5 provinces is page 002-16 at paragraph 47.
Yes, thank you.
So, my lord, those 2 facts we submit constitute a clear limitation of expression rights. Because we know from the authorities which we've cited in our heads of argument that expression is not protected just so that people like ETV and the SABC have the entitlement to say things and to express themselves. The purpose of freedom of expression is actually for the public to be able to receive ideas. That's where the value lies. In the receipt of ideas by members of the public, to allow them to participate in the marketplace of ideas. That is, the Constitutional Court has said that on a number of occasions, and we've set that out in our heads of argument at paragraphs 8 to 9. And the Constitutional Court and the SCA have recognized that television is the primary medium for receiving information in our democracy, in particular for poor and indigent households where literacy levels are lower. And access to television is necessary to allow meaningful participation in the marketplace of ideas. And we know, my Lord, that it is common cause that the people we are talking about now are indigent households who cannot afford to migrate themselves to digital. They cannot afford to buy them. Even if there were set-top boxes available in the shops, which we know from the pleadings there aren't, or aren't enough of, even if they were, these are people who can't afford to make that migration, and they can't afford to get even the cheapest DSTV package with no sport, but which will at least allow you to decode digital television. So we know that the impact is disproportionately going to harm those who are most vulnerable and who are already most excluded from our public discourse. And we say that is an obvious limitation of the right to free expression. Secondly, my Lord, it is also what our courts have referred to as a retrogressive measure. Because these people currently, and for the last few decades, have access to free-to-air television. The state is taking an existing access to a fundamental right, and it is reducing the extent of protection by taking away that access. And our courts have held time and again that that constitutes a retrogressive measure. Retrogressive because we achieve a certain level of rights protection and then the state decides to roll that measure back and remove that access. And, my Lord, if I can just refer you to the two judgments we refer to in our heads of argument. The first is the Juma Musjid case, where the Constitutional Court dealt with a case where a private property owner took steps to evict a public school because the Department of Education had failed to pay the rent on that property. And the Constitutional Court held that the department there had breached its negative duty not to interfere with existing access, and it said that the negative duty was breached when the state takes measures to diminish existing protection. That's paragraph 58 of the judgment. It's on case lines at page 020-32. And so this is plainly a retrogressive measure because there is existing protection of expression rights, and the analogue switch-off is going to take that away from at least 1.3 million people. And the second judgment, my Lord, is the Grootboom judgment, where at paragraph, it's at page 020-73 of case lines, and it is paragraph 45 of Grootboom. What the Constitutional Court said, that was in the context of socioeconomic rights, but it said any such retrogressive measure must be, requires careful consideration and must be justified by reference to all the rights. In that case, it was in the Covenant of International Rights. But we submit in this case, because you're dealing with rights in the Bill of Rights, what is required is the most careful justification in terms of Section 36 of the Constitution. So, rights are going to be limited. It's going to be a retrogressive measure. What that means is that if it's going to pass constitutional muster, there must be a justification in terms of Section 36. Mr. Marcus already pointed the court to the authority, which is very clear that the onus to put up the facts in justification of any such measure lies upon the state, and in this case the minister, and they must put up either the factual or policy considerations which would justify that limitation. That's the Moise judgment and the Nicro judgment, which we've cited in our heads of argument. Now, my Lord, with respect to the Minister's case on this score, we say he really says only two things which would justify this limitation of fundamental rights. The first is that he says that digital migration has already been long delayed, and we cannot continue to be held hostage by those who haven't bothered to register themselves to be migrated. They haven't taken steps to protect their own access to television, and so it's not for the state to hold their hands and carry them along into digital migration. Now, in relation to that point, my Lord, we say firstly that the 1.3 million we're talking about have registered. The 1.3 million are people who, on the Minister's version, have registered for a set-top box, and on the Minister's version are not going to get a set-top box before they lose access to television. And secondly, my Lord, we know that the terrible delays in this case are due to the Minister's Department and Centec. It is what a member of the Parliamentary Portfolio Committee aptly described as poor project management. It's poor supply chain management, it's insufficient procurement of equipment, it's delay after delay after delay, long periods of inactivity on the part of the state. It's a story that has unfortunately become all too familiar in South Africa, where our state capacity to do what it wishes or has to do simply lets us down. And so you can't blame the delay on anyone other than the Minister's Department. That's the first justification, which we say is no good. The second is that we get this allegation that dual illumination is expensive, and the state has decided to stop paying for that expense. And the Minister says it's cost 1.3 billion rand, and government has taken a policy decision that it no longer wishes to incur that cost. Now, my Lord, in relation to that allegation, we have the following submissions. The first is that number of 1.3 billion rand is completely unsubstantiated by any objective evidence. The Minister just says it's cost 1.3 billion rand. It is also disregards the fact that that was the cost over the entirety of the previous decade of dual illumination. And the Minister makes no effort to tell the court what it costs on a month-to-month basis now. And he also ignores the fact that the broadcasters themselves are carrying a significant part of that cost, which ETV makes clear in its replying affidavit at paragraph 54. So we submit, my Lord, that that bare allegation does not come anywhere close to discharging the evidentiary onus which the Minister bears in this case. And, my Lord, we make that submission in particular in relation to the submission that the cost is too much, in reliance on the SCA judgment in the Basic Education for All case, which we referred to in some detail in our heads of argument.
Yes.
It's an SCA judgment. I would simply commend to my Lord to read that case, because when I was preparing to make my submissions and I reread that judgment, what strikes one is that the degree of similarity between the facts in that case and the attempted defense by the Department of Education and the facts in this case and the defense which is put up by this Minister. Because that was a case where there was a failure to provide textbooks to learners in the Limpopo province. It was established that those learners were overwhelmingly amongst the most vulnerable. They were overwhelmingly poor and black learners. The department had decided to change curriculum, and so there were practical difficulties which arose because they were running two curricula at the same time, almost a dual illumination period when it comes to curriculum. And government simply failed to effectively fulfill its promise. It had promised to deliver these textbooks, and for a range of reasons, it didn't manage to deliver them to all of the schools. There was again, as there is in this case, a dispute about the numbers of affected pupils, but it came down to about 2.3% of students in the Limpopo province who hadn't received their textbooks. That's at paragraph 28 of the SCA judgment. There again, it was NGOs like my clients who litigated to try to assist, to force government to do what it had to do for those pupils. And there again, it was because the department's plan had failed that the limitation of constitutional rights came about. And again, the Department of Education blamed the schools. They said, you schools have failed to register, you didn't participate properly in our registration process, and so that's why we didn't get there. And again, as here, the department told the court it didn't have funds available, and if the court told it that it had to provide these textbooks, it would be infringing on the separation of powers. And so it was essentially the identical problem, the identical defense. And what the SCA did at paragraphs 36 to 43, my lord, is that it rejected that defense by the Department of Basic Education. It held that a violation of basic rights could only be justified under Section 36. It held that the Department of Basic Education had made a commitment, a public commitment, to provide those textbooks, and in granting the court order, the court would not be infringing separation of powers, but only holding it to its own public commitment. And it held, my lord, like here, that the Department of Education's logistical efforts to deliver textbooks was inadequate and woeful, were the words the SCA used to describe it at paragraph 43. It said there had been no proper planning, there had been no substantiated evidence that the department was unable to procure funds to deliver these textbooks, and as a result, the court set aside the defense based on a lack of budget as fallacious and contrived, and made the order that there was a breach of the Constitution and that the state would be held to comply with its own duties, with its own public promises. So, my lord, we have made submissions in our heads of argument, and I won't repeat them, that there is a repeated public promise by the minister not to leave anyone behind, and we would simply point out, my lord, that that promise is repeated again in the answering affidavit. It's in paragraph 3.3.4, where the minister repeats that promise. He says, we promise not to leave anyone behind when we do analogue switch-off, but we know from the common cause facts that he will leave 1.3 million people behind if it is switched off on the 31st of March. And that breaches the principle set out in KZN Joint Liaison and Pretoria, which we have set out in our heads of argument at paragraph 27. It would be unconscionable state conduct to allow the minister to breach his own seriously made promise that no one will be plunged into television blackout as a result of the date of analogue switch-off. So, my lord, that concludes our submissions on the public promise. If I may now briefly move on to the consultation point. We don't repeat what our learned friends have said about the consultation having to relate to a particular date. We entirely agree with those submissions, and we agree that it is common cause that never happened. It was simply a fait accompli that the December 2025 date was pushed back to December 24 was pushed back to March 25 without any consultation about the March 25 date. All that we wish to add, my lord, is that it's even worse in relation to my clients, because the Constitutional Court, in its judgment at paragraph 52, made expressly clear that any consultation process leading to a determination of date of ASO had to include MMA and SOS. They were interested and affected parties, and they had to be included in those consultations. And it is common cause on these papers that my clients were excluded from those consultations. That is set out in detail in our heads of argument at paragraph 34. And the chronology there, my lord, is that my clients didn't sit back and wait. They repeatedly wrote to the minister asking to be involved and asking to be consulted. And they started as we say in paragraph 34.1 of the heads of argument, on the 9th of March 2023, writing for a request for a meeting and a consultation. The Minister did not respond. On the 20th of March 2023, they wrote again, requesting a response. The Minister did not respond. And now, my Lord, at paragraph 34.3 of the heads of argument, this is maybe the most important factual allegation which is not contested in relation to my client's exclusion. Before promulgating 31 December 2024 as the ASO date on 14 June 2023, the Minister gave MMA and SOS no advance notice and no opportunity to make representations. That is paragraph 16 of the Bird affidavit at page 003-7, and it is not addressed in answer mode. So then we've got this date of 31 December that my clients were never consulted on. My clients then start writing to the Minister, 16 August 2023, 28 November 2023, repeatedly requesting to be consulted. And what you see again and again is there's no response until the 20th of December 2023 when the Minister writes back and he says there is no need to consult anymore because we have already consulted extensively on the ASO. That, my Lord, you find at page 003-37. And then, my Lord, there were these meetings with broadcasters in the Broadcast Digital Migration Committee, which MMA and SOS were not invited to. We don't say that those meetings constituted an adequate consultation, because as Mr. Marcus has explained, those meetings never concerned a particular date of switchover. But even though it was inadequate in relation to the broadcasters, it was even worse in relation to M&A and SOS because they were excluded despite their repeated attempts to be included. And we then accelerated towards the end of December last year. And again, there is just, despite these attempts, repeated attempts by my clients to be consulted, they get ignored. And then they are finally told on the 5th of December, we have now decided to push the date back to 31 March 2025 without any consultation about that date. And so throughout that time...
Sorry, when the Minister said we do not need to consult as we've already consulted, how did you understand that? Was it a reference to the June consultations, June 23? What consultations was the Minister referring to, in your understanding of that response?
My Lord, if the court goes to the letter, it's at page 003-37. Yeah. And one has to read paragraph 4 of that letter in particular. And what the Minister says is, he notes that my clients are concerned that it has directed correspondence to our client regarding a matter of national interest regarding the ASO. The ASO has already been a subject of lengthy litigation and a constitutional decision. Your client directed correspondence to our client in order to avoid further litigation regarding ASO. And it is crucial that the issue of availability and installation of set-top boxes are dealt with, and your client requested a further urgent meeting. And then at paragraph 5, our client is at a loss in an attempt to comprehend what your client's letter under reply is intended to convey, except for a threat of litigation in the event our client fails to meet with your client. And then here at paragraph 36, that being said, paragraph 6, that being said, as far back as 6 March 2023, our client directed a letter to your client addressing the very same issues, a copy of which is attached. And then he says on 16 June, as you will note from the attached report of June 2023, our client has already consulted extensively on the ASO. So what is being referred back to is the process that my Lord raised with Mr. Marcus, the June 2023 process. Yes. And what we submit is that that process was A, inadequate because it didn't relate to a particular date, and B, my clients did not participate in that process because they were excluded despite repeatedly asking to be included.
Yes, that was going to be my next question, whether you participated. I wasn't sure.
No, my Lord, and that's why I referred to paragraph 34.3 of our heads and paragraph 16 of the affidavit of Mr. Bird. And none of the allegations in Mr. Bird's affidavit are responded to by the Minister at all. I don't know if whoever was drafting the papers just missed the fact that there was an affidavit, but there's no ad seriatim, there's no response thematically, they're just not addressed. And so those must be taken to be common cause.
Yes. Well, I do not want to belabor the point by asking whether you did point out to the Minister that in fact what you're referring to, we were excluded from that process, so you haven't consulted with us.
Yes, yes.
But in light of the fact that it's common cause, that it seems there was.
Yes, well, the one thing I can assure you of is that the letters written on behalf of my client made that point repeatedly. And they are annexures WB1, WB2, WB3 to the correspondence and the preceding annexures. And what you will see is that from 9 March 2023, my attorneys were writing to the Minister on behalf of my clients, making submissions and pointing out and asking to be included and consulted with, and pointing out that they had not yet been included and consulted with. And in respect of the bulk of those letters, there was simply no response.
Yes. Thank you.
So, my Lord, I'm now on to the final point, the elements of interim relief which are satisfied.
Yes.
We say, following from that consultation point, in relation to the balance of convenience, that we expect that our learned friends will tell the court that because this is government conduct, to get an interim interdict, you need to meet the heightened standard which the Constitutional Court set in the outer judgment. You have to show the clearest of cases of illegality. We submit with respect, following from the point about inadequate consultation, that one could hardly get a clearer case, because what you have is a Constitutional Court decision which says you have to do A, B, and C in order to take this decision lawfully. You have to consult with MMA and SOS, and you have to consult with them about the date that you are contemplating. And then it's common cause on the facts that that doesn't happen. And so this is the clearest of cases. You've got a Constitutional Court roadmap which was not complied with. So we submit that outer does not count against the relief that my clients seek. In relation to the prima facie right, the rights that we say will be harmed in the interim, because the court will be aware that to grant interim relief you have to conclude that there are rights which would be harmed between now and the Part B review if the interim relief is not granted. And we submit that is manifestly satisfied, because there will be a television blackout for at least 1.3 million people, and that will harm their right to receive information, and that will be an irreparable harm to their rights of freedom of expression. There will be the right to have the promise not to be left behind fulfilled, which will be breached. And there will be the right of my clients and the public to a lawful process of consultation in accordance with the Constitutional Court judgment, all of which, if there is no interim relief granted, will be irreparably harmed in the interim period. And then, of course, there are obvious prospects of success in the review. So we say the prima facie right element has clearly been established.
Yes. In saying it will be irreparably harmed by the blackout, as against the minister's promise to rectify that by December 2025, does that say anything?
No, because you will then have a 9-month period of information darkness, which can't be remedied by switching broadcast, which can't be remedied by having a set-top box installed in December, because then you have then gone through 9 months of no information. That's why I say it's irreparable.
I see. Sorry, and then you addressed the prospects of success.
Prospects of success in the review, which the Constitutional Court in the informal traders case has said is one ground upon which one establishes a prima facie right. And it's not just the right to review, of course, because if analog switch off happens in 10 days' time, then what is the point of reviewing the decision to set the 31st of March 2025 as the date? The Minister will, by turning off the transmitters, render the Part B of this case moot, because there will be no practical effect if the Part B succeeds. It's not as if the court will then tell the court could conceivably say, Minister, your decision to set the date was unlawful. We know you switched off anyway. You are now ordered to turn those back on. But by that time, firstly, the harm will have been done. And secondly, the horse will have bolted. Will be however many months down the line. And all those people who have been unable to migrate will have been sitting in television darkness for that time. And things will have moved forward. So the review will be practically meaningless. And, my Lord, may I say, in relation to the 31 December 2025 date, we don't accept that it will be done by that date. There's no evidence that it will be. If you look at Centec's historical rates of installation, that looks extremely unlikely, because it's been bedeviled by delay after delay after delay, long periods where they were installing only 3,000 a month. And so if the past track record is the basis of thinking it's going to be done by the end of December, it's simply unrealistic. And finally, my Lord, I've addressed the question of the balance of convenience under the heading of the outer case. We say in reliance on basic education for all, there is no separation of powers harm, because you are holding government to its own public promise and its own policy. And so, as in basic education for all, the question of separation of powers harm does not count against our belief. And we submit, my Lord, finally, that there is no serious suggestion of any alternative remedy that could cater for the 1.3 million people during the interim period, or which could remedy the commercial harm which will be inflicted upon the SABC and the other community broadcasters. My Lord, we would also ask for our costs to follow the result. We submit that costs of 2 counsel on C scale would be appropriate in this matter.
Thank you, Mr. Ferreira.
Thank you.
Mr. Tsawa.
May I please do one of we have suggested to a lead counsel for the applicants that we answer both cases tomorrow morning, and that they can reply after that. There's also an issue which has come to my attention about the affidavit that Mr. Marcus told you was going to be filed on behalf of Centec about the remaining numbers of qualifying beneficiaries who must still get set-top boxes. It is an issue that requires that I consult with both the first respondent and Centec. That affidavit has not yet been filed, but importantly, it seems to suggest that the factual position which I communicated to Mr. Marcus this morning, and I think yesterday as well, may actually be different. So
May actually?
May actually be different. So it's something that I do need to consult on and get an understanding of what the correct position is and what caused the change. Because it is an issue that I'm sure is going to arise in the plan, so I will need to do it. So on that basis, my lord, we ask that we respond to the applicant's case in the morning tomorrow, and then the applicants can reply shortly after that. I don't expect that I will be more than an hour and a half in my main address. That's it, please.
Maybe I need to hear from the applicants.
That's it, please.
Lord, I didn't quite have the same understanding as my learned friend. I understood that the affidavit was simply awaiting commissioning, and hence I conveyed to your lordship with my learned friend's approval the number of 405,000 households. So I'm a little bit in the dark about that, and dare I say, my lord, this is not just the 11th hour, this is more than the 11th hour. That said, my lord, we are in your lordship's hands. There is an alternative, and that is that my learned friend does his answer, and it's indeed possible we could finish today, but I leave it entirely to your lordship. But he could answer now. If there is an affidavit overnight, he could deal with that in the morning, and but I really am bewildered by what I'm being now told.
Yes, well, I have requested your response because if it's about what I call the play on the numbers, you've already made your submission that your conservative view relies on the numbers presented by the minister himself. But you are saying, well, moving from that, there could be more. There are more than just the numbers. But you are saying on what the minister says, it's millions of people overall, and you have also referred to the BRC information, which increases the numbers. Now, if that affidavit is available, it's a question of, well, are there more or are there less? But it doesn't make a difference to the case that you present. So, is it that critical that we do not proceed?
It's in our submission, it's not that critical, my lord. On any basis whatsoever, the numbers are massive. And but I leave it to your lordship. It seems we are in the urgent court. It's your lordship's time, which is also at issue. And we will do as your lordship directs.
Yes, I asked this before you sit down is with agency, yes, which is agreed between the parties. So I do not make a finding on that. But also the consideration of the matter by this court and giving a judgment between now and in 10 days' time is a matter to be considered also. So any delay that pretends that we have all the time so we can be leisurely about it is not just suggested by the facts themselves, but also the practicalities of coming out with a finding, which is what this court is also concerned with. Maybe the parties not, because they've done their part, but it has to be a serious reason that delays us and causes an inconvenience then in deciding.
Lord, we are acutely aware of your lordship's position.
Yeah.
And that is why I'm hesitant to agree to my learned friend's suggestion. The farthest we will go is to say that it is not ideal, but we leave it in your Lordship's hand.
Yes, thank you. Mr. Kasawan, you've heard.
Well, I don't know if Mr. Ferreira wants to
Sorry, yes.
comment on that.
Yeah.
I'm sorry, we are also in the court's hands.
Yeah.
It does seem to us that there are issues which have nothing to do with the affidavit, which could productively be dealt with in this afternoon session. But we take it no further than that.
Yes.
Please, sorry, if I can just reply. My lord, it's not only just a question of the affidavit, but it's also about how we're going to present our argument in terms of structure and cross-referencing to the documents to which you have been referred. Mr. Marcus is right when he says that what I'm conveying to the court now is not consistent with his understanding. But that is exactly the reason why it is necessary that we be given an opportunity to consult with both Santec and the first respondents to understand what has now led to the change that I'm referring to. I think it is only fair. There isn't going to be a delay that creates further problems for the court, because we sat down for 2 days, today and tomorrow, and we will finish the case tomorrow. There is absolutely no reason why the case should not be concluded by tomorrow. As I said, I estimate that I'll be an hour and a half to an hour and 45 minutes, and then replies can come shortly after that, and then this case will be done by tomorrow as originally planned.
But Mr. Kasawan, the reference document,
Yes.
references document argument that was presented this morning does not present a case that was not, that the respondent would not be aware of.
Correct.
He has merely tried to fine-tune and perhaps make it easy even for the court to, along with his submissions this morning, be able to reference the documents and to reference the judgments that are referred to and so on. But it's not anything new.
No, we accept that, yes. But what we're saying, we want to then structure our response along the lines that is presented in that document. It will be beneficial and of use to the court if we don't jump around the papers, but we go chronologically in the manner in which the applicants have done their case. So we submit, my lord, that again, this is not going to delay the finalization of the case. We already sat down for 2 days.
Yes. Of course, the last thing that the court wants to do is to inconvenience any party in presenting its case, purely because maybe the court wants to rush and finish the hearing of this case in order to get on with the weighing of the submissions and the evidence. I'd be reluctant to do that, to say, no, just get on with it. This is an urgent matter. And yes, it is correct that the matter is set down for 2 days. And I hear your submission about your certainty that the matter will conclude on the allocated dates or the allocated time. But I'm certain you're sensing the reluctance in me to engage in any conduct that would be translate into a delay of the matter, however short. But it's only on that consideration that I will agree and hold you to your timelines in terms of your submissions tomorrow.
Why in that area?
In the circumstances, the matter then will adjourn to tomorrow at 10 a.m. Sorry.
My Lord, could I beg your indulgence? I'm not questioning your Lordship's ruling, but I wonder whether your Lordship or my learned friend could give some sort of a commitment by when we will get this affidavit.
Yes, no, the affidavit has to be delivered today by close of business so that we don't have any other issues hanging around that.
Indebted to your Lordship.
And if
We
it's
commit
not,
to that.
yes, please. Court adjourns.
All right.